Okay, well, hopefully my mic is working now. If not, somebody will let me know. But welcome to Bianchi Law Talk, Sundays, 5 o'clock. The huge things are occurring in the Supreme Court of the United States, as you know, and people are asking the question, what is the new justice, Justice Kavanaugh, going to mean to the Supreme Court? Well, these decisions have profound impact, as you can tell. Now, Justice Scalia had died, and now he's replaced by another Justice, Gorsuch, as well as, thank you guys for letting me know my mic's working, is now Justice Kavanaugh. So this can have huge implications going forward as to decisions that have been very marginal on the line. 5-4 decisions. That is, 5 justices agree with one thing, 4 justices agree with the other. Now, to use the vernacular that people say, up to this point in time, it has typically been on the liberal side, especially because Justice Kennedy, who's more of a conservative judge, went moderate to liberal on a couple of decisions. But now that he's gone and they're replaced by 2 very conservative justices, you could see some profound changes and impacts in constitutional law. What is one of those areas? Affirmative action. Now, look, there's a legal side to this and a political side to it. I want to try to put a poll up there later if I have an opportunity, because I'd love to see what your viewpoints are. But nevertheless, put them in your commentary if you can. On the legal point, where does affirmative action come from? Well, if you recall, during the Reconstruction period after the Civil War, there were states that were still segregating and discriminating. And the 14th Amendment of the United States Constitution indicated that you cannot deny or abridge the rights of any citizen. You have to give them equal protection under the law. And because it was a federal constitutional amendment, it therefore applied to all of the states. So no states can pass a law that discriminates against any person based on, in this particular case, race, which was the reason why the 14th Amendment to the United States Constitution was made. Well, what's going on, therefore, with affirmative action and race-conscious decision-making processes that are allowed in schools? Well, we're about to find out if this new shift to the conservative side in the Supreme Court is going to make a difference, because there is a case winding around the federal courts right now. It was brought by Edward Blum, who's a person who's been bringing out anti-affirmative action guy, with a bunch of Asian students who were denied admission to Harvard University. That's right, the biggie, the Ivy League college, Harvard. And they're saying that the race-conscious decision-making of Harvard University discriminates against them as Asians, another minority group. Now, this is an interesting case because it's the first time on an attack of affirmative action where one minority is saying it's being discriminated because they are better qualified, they have higher grades, higher SATs, and they're being denied admission in favor of another minority. So it's the first time we have a little bit of a twist there. And these little twists are the wiggle room that the courts can go forward and say, hey, we see a distinction here. But let's talk about affirmative action in general. Where does it come from? Well, essentially what we know from the Supreme Court is a quota system is illegal. It is not proper to have a quota system in place. But you can have race-conscious policies and give some weight to race because they consider diversity a very important thing. So when this originally went to the Supreme Court, there have been many decisions that have come out that say, and Grutter versus Bollinger in 2003 was one that was a biggie, because they indicate, and I quote, race-conscious admission policies are constitutional because, and here's where people get confused. They're like, well, wait, it discriminates. Yes, you're allowed to do that if there's a compelling state interest and it's narrowly tailored. And what the court's reason is because of the unequal playing field and because of slavery and because of the difficulty of minorities and racial prejudice, so on and so forth, that there was a compelling state interest to bring diversity into schools. And so long as it's narrowly tailored and not a quota system, that is a compelling state interest under the strict scrutiny test of the United States Constitution that upheld the use of race-conscious policies, also known as affirmative action, in the admissions process. Now, that was a 5-4 decision, and in favor of affirmative action. And one of the justices was Sandra Day O'Connor, who was really a conservative justice, but she went on the side of the majority there, upholding affirmative action. But you have to be careful about what she wrote in her opinion, which is, we expect in 25 years from now the use of racial preferences will no longer be necessary to further the interest approved today. That is diversity in schools. Now, that was in 2003, but essentially what she was saying is we'll uphold it because there's a compelling state interest. It's narrowly tailored. There's a need for it, but there may come a time where there's no longer a need for it. It's kind of a little prognosticative, prediction that she was doing there. And she also indicated in the decision that the schools need to find alternatives to race-conscious admission policies to close racial gaps in admissions. Now, this is interesting, racial gaps in admissions. In Harvard right now in this lawsuit, there are essentially over 50% of the school is minority right now. So the question becomes, has the compelling state interest of race-conscious decision-making in order to get these kids in school, has it been met, and should it now end? Because it is, in fact, a discrimination. It's just a permissible discrimination under the strict scrutiny test because there's a compelling state interest. So Edward Blum and these Asian students filed this lawsuit saying that their 14th Amendment right to equal protection under the law has been violated. And they're saying that basically the strict scrutiny test no longer applies to school admissions, given the fact that more minorities are at Harvard than not. Now, another interesting thing about what Harvard did here, at least this is what's alleged by the Asian students, is they look at a bunch of factors for admission. To be honest with you, I've tried to look into these factors. It's very difficult to figure out what they're doing here. Of course, the Asian students and Edward Blum say what they're doing is a quota system, doing the thing that they're not supposed to be doing it, and they're just calling it something else. And it is alleged, for example, that the Asian students' scoring gets dropped precipitously because they have a category that's called like likability, or, getting along with others. And apparently it's weighted very heavily against Asian students, which when I read it, if it's accurate, and we'll see when the testimony comes out, they're saying a class of people, Asians, are not, I guess, as friendly or integrative as other students, which I found to be an extremely strange thing. Nevertheless, this category, whatever it is, drags the overall score of the Asian students down, thereby making other minorities move higher in the scoring process. Now, I want to tell you about one last case. I know it's heady law. People don't necessarily like it. I really like it because, man, if you figure out what's going on here with this affirmative action case, this could have implications in every other area where there were narrowly split judicial decisions. We talk about precedent. That came out a lot with Justice Kavanaugh. Yeah, precedent is precedent, but there are always ways to get around precedent. And there's always ways, like Justice Sandra Day O'Connor said, to say at a certain point in time, the compelling state interest under the strict scrutiny test is gone. So let's look at this case, Abigail Fisher versus the University of Texas in 2016. This will really illustrate to you the meaning of Justice Kennedy leaving and Justices Gorsuch and Justice Kavanaugh now on the bench. Justice Kennedy, again, a conservative justice, but he kind of moved towards the center with these affirmative action decisions in a 5-4 decision again in 2016. And keep in mind, the time that this decision was made, Justice Scalia was dead, and Justice Scalia hated affirmative action. That would have led to a tie in the court. But now, again, the balance has gone to the more conservative side. In this case, a white woman was denied admission to the University of Texas and argued that her 14th Amendment right to equal protection under the law was being violated because, quote, lesser qualified minorities were admitted. Now, that decision, again, it was upheld that the admission policy was okay, but was in a 5-4 decision. So I suspect, folks, that the court has two options with this case. It's down at the district court right now where they're gathering facts and data and information, and the judge is going to rule whether or not the Asian students' rights were violated under the 14th Amendment. But you can be assured that regardless of who wins or who loses this case, it is going to the Supreme Court. It is ripe and prime, and it's a case of novel impression because it's a minority saying that they're being discriminated based on another minority class. So it's got all the little bells and whistles that bring it to the Supreme Court in my mind. So guys, what do you think? I got 4 questions, really. I had them in the poll before when my audio went out, but the one is, do you legally think that this change with these 2 justices will now end affirmative action, or will they just say, maybe the policy of Harvard's okay, maybe the policy's not okay, you need to change it, or maybe they'll take the big jump and just eliminate legally affirmative action in the admissions process, race-conscious decision in the admission process of these colleges? Or will they not do that? And then the second point, very interesting for, I like to ask this politically, because there is politics to all these decisions. Do you think affirmative action should end? Or do you think affirmative action should continue to ensure that we continue to have a diverse student population that has a little bit of a leg up there because they were traditionally discriminated upon class? Hey guys, listen, thanks always for watching Bianchi Law Talk. Sundays, 5 o'clock from this point forward. If you could share this video with your family and friends, it would be greatly appreciated. And for all you guys who support us at the Bianchi Law Group, myself and my partner David Bruno, we always appreciate that as well. Have a great week, and we'll come back with some more Bianchi Law Talk next Sunday. And of course, if you haven't joined yet, my new YouTube channel at Bianchi Law Talk on YouTube. If you haven't subscribed, I'd love if you could. See you next week. Bye.